Hi everyone, my name is Keith Budden. Welcome to the latest in this series of videos about GDPR. As you're all no doubt aware by now, I'm recording one of these every day between now and May the 25th on different subjects of GDPR, different aspects, hopefully bringing you up to speed on some things, making you think about some things. Some of them are deliberately designed to be thought-provoking. If there's anything I'm not covering, then please do either send me a comment or send me a private message and let me know, because I really do want to make sure that I cover as many subjects around GDPR as I can between now and May the 25th. And as we all know, GDPR Day is now rapidly approaching. So we do need to start all thinking, I hope by now you're all thinking about how GDPR is going to affect your organisation or your business and quite what you're doing about it. Anyway, enough of a preamble. Today I want to talk about staff privacy policies, because this is one area which is quite often easy to overlook. So, you know, by now, hopefully, you've got a lovely GDPR compliant privacy policy on your website. So all your people there, everyone comes to your website, it's nicely covered. You might even have a nice GDPR privacy policy you have for when you collect details in person. I hope you have by now. I hinted at that the other day. And again, you can use that, and that's all good. But what about your employees? Because do you know what? They each need a privacy policy too, and their privacy policy has to have different wording in it to the privacy policy that you have for the general public on your website or in person. Because the information you hold about your employees is very different to the information that you hold about other people. You hold some very personal information about them. You hold obviously how much they're paid, but you might also hold some vital interest information for them. For example, you might hold things like whether they're diabetic or epileptic or have some other health condition which people need to be aware of. And maybe all sorts of information you hold about them as employees. And that's why it's important that you have an employee privacy policy. Now, I've discussed it with a few people over the last few weeks, and the response I've had from some companies and some organisations is, well, that's all right because we cover off that privacy in our contract of employment, and people sign a contract of employment and that's all fine. Well, no, it isn't, because the regulations are quite clear that a privacy policy or hints towards a privacy policy contained within a contract of employment don't satisfy the requirements of GDPR. GDPR must have a separate document which people sign, or somehow, maybe online otherwise, indicate that they've read and accept. And the reason for that is because, if you remember back when we started all this a couple of weeks ago now, one of the key elements of GDPR is that consent must be voluntary, and it must be informed consent. People must know what they're signing up to. So you can't have it buried away in a couple of paragraphs in your employment contract. It has to be a very clear, specific document about that's what this document is, that's what we want you to sign. So, not surprisingly, I'm going to have a brief commercial here and say, of course, I can provide you with perfectly GDPR compliant wording for such a policy. And if you get in touch with me, either via Facebook or LinkedIn, I'd be delighted to talk to you about how I can let you have that document. But the other side of it is also, of course, that what if one of your employees refuses to sign it? They're perfectly within their rights to refuse to sign it. It's not part of their contract of employment. If they refuse to sign it, what do you do then? How do you handle that? I'm hoping it never happens to you, because it does make a very difficult situation. It's not good for employee relations, and hopefully all your employees will read the privacy policy and be happy with it. What I would say is make sure you've read the privacy policy yourself, you 100% understand it, and more particularly, of course, that your HR team 100% understand it, so that they can explain any questions that any of your employees have, and hopefully avoid the situation where you have an employee who refuses to sign it. But one area as well where employees, if they wanted, could be decidedly difficult is they can say, I don't want you to process my payroll via an outside payroll bureau, if that's what you do, because they're entitled to do that. They can say they're not happy with that data being transferred. They want you to do the payroll in-house. Now, hopefully no one will raise that. But what if someone does? How do you handle that? What are you going to do about that? Equally, you need to make a clear decision, and it needs to be a documented decision. This is the important thing about so much of GDPR, is that decisions are documented. You need to have a board meeting or a management meeting, and you need to clearly document what information on an employee's employee file you would be willing to disclose to that employee and what you wouldn't. And you need to have very good sound reasons for having items that you won't disclose. The other thing here is, if it escalates at some point with an employee, that you have a disciplinary action with that employee can ask to see now copies of all communication within the company about them. So if there have been emails between management team and middle management maybe about an individual, that individual can now demand to see them, and they're perfectly entitled to see them. Now, in revealing those documents, you are entitled to redact the name of who sent it and who it was sent to, so he doesn't know who said it. He or she, rather, doesn't know who said it or who it was sent to, but they must be able to read the message. You must not delete those messages, because that in itself is an offence under GDPR. You also need to be very careful where you have company-issued mobile phones, because if employee A has slagged off employee B on their mobile phone, and employee B gets to hear of it, he can demand to have a transcript of that conversation. He can demand to see those text messages. And again, you can redact the phone number, so perhaps he doesn't know whose phone it was, although I guess in most cases people would have a fair suspicion. But you can't delete the message itself if that message existed. So you do need to be very, very careful. I would say, particularly after May the 25th, ensure that all of your staff make it a clear message to management and indeed lower levels of staff that discussions about other members of staff take place only verbally, either over the telephone or in person. But they don't take place by text message, they don't take place by email, because in a disciplinary situation now, the employee is entitled to see all of those. And of course, should it go further to a tribunal or whatever, can use those to potentially get damages against the company or the organisation. So once again, hopefully, a subject that's given you some food for thought. Hopefully, you're finding all these videos interesting. Please do leave me comments or likes, because I do read them, and I do try and build on them as we go through this series of videos. So that's the end of the video for today, and I'll speak to you all again about a different GDPR topic tomorrow. As I've said before, by the way, if you have any ideas on topics you'd like me to cover, please do let me know, because then I can make sure that I cover them for you. Thanks for watching, and bye for now.